The question is that the motion be agreed to. Mr. Speaker. The Honourable Phil Goff.
Mr. Speaker, the Labor Party has a long track record of supporting legislation that will enhance the safety of the public, and in particular legislation that will protect the interests of victims and prevent them from being re-victimised. So our decision in respect to this legislation is initially to support it to the Select Committee. That's the normal step that we would take. The Select Committee gives us the opportunity to listen to the pros and cons of the legislation, whether it goes far enough, whether it goes too far. But in terms of the objectives of this bill, I have no problem with the objectives if the legislation actually meets what the objectives set out. And the objectives are to, first of all, improve the integrity of the sentence. When a person is convicted and sentenced for a particular crime, then we want to make sure that the sentence is carried out as it should and that the offender complies with the terms of that sentence, and that becomes an issue when the offender is out in the community rather than locked up in prison. Secondly, if the bill is successful in safely managing offenders in the community, then everybody benefits. The offender benefits if they are discouraged from re-offending in a way that would see them simply given a harsher sentence and leaves them with the prospect of spending more of their life locked up. And of course the community and potential victims benefit. So those are the thresholds that we're looking at. It's also important that the legislation works in a cost-effective way and in a reasonable manner. I think the Minister himself talked about the balancing of the rights of the offender, and offenders don't lose all of their rights, and the rights of the community to be safe. So we want to make sure that this legislation finds that balance appropriately. Back in 2002, when we passed the Sentencing Act, there were provisions in the Sentencing Act, as it exists today, that prevent the imposition of electronic monitoring in particular circumstances. Electronic monitoring can't be used in respect to a sentence of supervision, to a sentence of intensive supervision, to a situation where somebody is released from prison, where the sentence has been 2 years or less, and where somebody is released from a sentence of home detention. And people might ask, well, why would the legislation actually stop the use of electronic monitoring? Well, the reason that the Department of Corrections and the Ministry of Justice gave me at the time, and they're still giving to the Minister, is that there is a danger when you bring in a new form of sentencing that a phenomenon called net widening occurs. If the sentence is there, it'll be used, sometimes whether it's cost-effective or not cost-effective, justifiable or not justifiable. And at the time, the strongest recommendations were that electronic monitoring ought not to be used in these 4 areas. Now, the Department of Corrections, and I presume in conjunction with the Ministry of Justice, have looked at this again, and they have reiterated in terms of 2 out of 4 of those categories that the use of electronic monitoring is still not the right way to go. They say in relation to a sentence of supervision that this does not justify the expense of electronic monitoring, and it's not justified by the risk that the offenders actually create for society. Supervision is actually low in the hierarchy of sentencing, and therefore why would you waste $3,500 in electronically monitoring somebody that has been sentenced to a relatively light sentence and is not likely to re-offend? They've also ruled out, for similar reasons, the use of electronic monitoring in relation to release from home detention. A person that has complied with all their conditions through home detention, they say, constitutes a low level of risk, and we could not justify, they argue, the imposition of electronic monitoring either in terms of its cost or in terms of the infringement, the further infringement on the liberties of a person who has been released from the sentence of home detention. And I accept those arguments in those 2 cases. In the other two cases, they say there is an argument for the use of electronic monitoring. And I think it's worth remembering that the electronic monitoring that's available today is quite different in nature from that was available 14 years ago. In those days, it was all radio technology with the bracelet. Now you have a phenomenon called global positioning satellite that can tell you exactly where the offender who is out in the community has gone and can alert you to where the offender when the offender goes to an area that is prohibited under the terms of their sentence. And I think that that makes sense. The first category is imprisonment for 2 years or less. And sadly, when we look at every sentence, the sentence where there is the highest rate of reconviction is where an offender has been sentenced to a short sentence. Makes you wonder whether the short sentence is actually particularly effective in meeting the requirements that we expect from it. But there is a high rate of reoffending, and there is an argument on that basis for allowing electronic monitoring of certain categories of people who have been sentenced to 2 years or less. I want to make it clear to the House that the electronic monitoring does not automatically apply to everybody in that category. It is still only applied at the discretion of the sentencing court. So we are relying on the discretion of the court not to overutilise this, but to apply it only in those areas where the court has reason to believe that this will protect the public and is required for public safety and the safety of victims. The other area that this will apply to, sir, is where somebody is under a sentence of intensive supervision. This is a little more challenging. Intensive supervision means that the person hasn't offended to the degree that the court felt it worthwhile sentencing them to home detention, but nevertheless that the seriousness of the offending was such that ordinary supervision wasn't sufficient and intensive supervision was needed. In this respect, I think there are some clear categories where electronic monitoring would be worthwhile. It's of real concern to members on this side of the House that domestic violence is increasing, the convictions for domestic violence, and I believe the occurrence of domestic violence is increasing, and protection orders are really only a piece of paper. They don't protect the victim in practical terms. So what electronic monitoring might do to an offender that has already offended against the victim is to alert authorities in real time if that offender goes near the home of the victim. And that seems to me to be something that is worth doing, Mr. Speaker, and I'd support that. There are other instances where there are no-go areas imposed as a condition of the sentence. If a person was convicted for a crime because they had an addiction, either to alcohol or to gambling, and you say we don't want that offender to go near the casino, then having electronic monitoring in real time, or even a record of it after the event, does enable you to discourage the offender from going back to the cause of his or her offending. And I've looked at the international evidence for this, and the international evidence says that the GPS system does act as a genuine deterrent in those cases, and therefore we would go along with that. Now, the areas that will be targeted for electronic monitoring are the family violence cases that I've talked about, gang-related offenders and high-risk sex offenders. I think if we are targeting those specific groups, then there is a justification for what this bill does. I want to touch briefly on the vet for consistency with the New Zealand Bill of Rights Act, and this bill has received a negative vet. That means that it's inconsistent with the New Zealand Bill of Rights. It provides, according to the Attorney-General, Mr Finlayson, unjustifiable limitations on freedom of movement, search and seizure and double jeopardy. But I think we need to dig a little deeper than that first analysis. And of course there will be limitations on freedom of movement if the individual exercising that freedom is going to breach their protection order. I don't think freedom of movement to a person that has been convicted and is still under sentence can be determined to have full freedom of movement. I think that's a matter of common sense. Unreasonable search and seizure, which is how they define monitoring. Well, if the monitoring actually does mitigate against real risk to the victim and real risk that the offender will re-offend, that might also be justifiable. And the last point, sir, is in terms of double jeopardy. It would be double jeopardy if this was being done for the purposes of punishment, but I believe that this is being done for the purposes of prevention. On those bases, the Labor opposition will support the first reading of this bill. We'll look at it closely at the Select Committee, and if it stands up to analysis and the evidence presented to us, we will continue to support it after that point.